This employment law video is on privacy. Employers must respect privacy and are only able to access emails and messages in limited circumstances. Employee right to privacy. The European Convention on Human Rights, which is incorporated into UK law, states that everyone has the right to respect for their family and private life, their home and their correspondence. The right is qualified, and there are some instances when interference with the right can be justified. In the employment context, there has to be a balance struck between the individual's right to privacy and the employer's interests. Although only public bodies must expressly comply with this right, it's relevant to all employers, including in the private sector, as the courts must interpret legislation consistently with the right. In most instances, therefore, emails and messages sent through private accounts outside work should be private, and employers would have no justification in scrutinising them. But there could be exceptions. Misconduct, damage to reputation. Employers may dismiss fairly for misconduct, and the misconduct may be inside or outside work. Damage to reputation could also be a valid reason for dismissal. For conduct outside work, a key question would be whether the employee's actions affect or could affect the employee's work, or whether there is or could be damage to reputation of the employer. Sending emails or posting messages outside work could fall within scope. Monitoring. In a European Court of Human Rights case, the court had to consider whether an employer acted lawfully in accessing an employee's private messages on a business Yahoo Messenger account. In this case, the employer's rules ban the use of IT systems for private purposes. Overturning the earlier decision, the court held that the right to privacy was breached because the domestic courts had not considered whether the employee had received notice of the monitoring. The following factors may be taken into account in monitoring cases: whether the employee had been notified about possible monitoring and been provided with adequate safeguards, the extent of the monitoring and the degree of intrusion into the employee's privacy, whether the employer has provided legitimate reasons to justify the monitoring, whether it would be possible to carry out monitoring by using a less intrusive form of monitoring than accessing actual content, and the consequences of the monitoring for the employee. Under the General Data Protection Regulations, the GDPR, employers are required to provide certain information to employees about processing personal data, which would include monitoring personal data. For more information about the GDPR and monitoring, please visit my website. That's my video on privacy. The usual caveat is that this video is for guidance only and should not be relied upon for specific advice. For more information, visit my website. And if you're interested in receiving notifications on other employment law videos, do subscribe to my channel.